Hello, everyone. It's been a while. There's just not been much going on. I have missed you guys. I hope everyone is doing really good. We've had some interesting times in the UK. I was sat in an entire, like the whole of my area had this. It wasn't even just Wi-Fi. It was everyone's phone networks and everything. Like literally, we all went back to the 80s over the weekend. That was wild. um, and we've had heat waves. Yesterday we had a thunderstorm. Now we're back to, I wouldn't call it a heat wave day today, but it's really hot. So, yeah, we've all been suffering here in the UK. I hope everyone is doing really well. I've got, so we've got an update from the Taylor Swift marine flag case. So then, and I'm going to go through that filing. I've then got a follow-up video as well, which I'll be doing. I'm also going to be doing a video as well on the Ian Watkins murder trial because that has collapsed spectacularly. So I'm to the information that was available about what was discussed, etc. And then the collapse itself, which was basically the jury was discharged for legal reasons, and I will talk about that there for the people who follow that case or are interested. Right now, though, I'm going to be going through Taylor Swift's motion to dismiss Marine Flag's case. Marine Flag has responded, so I'll do that in a separate video because this is some 30 pages, this motion. Okay. So there's the notice. Let me just see. Right, yeah, I'm not going to read the notice. I'll go through the table of contents. Table of contents. I'll go through the actual memorandum itself. Okay. Pursuant to Federal Rules of Civil Procedure 12b6 and 12b2, defendants Taylor Swift, TAS Rights Management, UMG Recordings, and Bravado International Group Merchandising Services, who are collectively the defendants, respectfully move for an order dismissing plaintiff Marine Flag's complaint. Plaintiff brings federal, trademark, and California unfair competition claims based on her trademark Confessions of a Showgirl, complaining about the title and associated promotional goods related to Taylor Swift's 12th studio album, titled The Life of a Showgirl. As explained in defendant's opposition to plaintiff's motion for a preliminary injunction, the premise of plaintiff's reverse confusion claims that consumers will believe plaintiff's cabaret-style goods and services are affiliated with or sponsored by Miss Swift is absurd. I find that interesting given that they themselves made the mistake and got confused. Indeed, this lawsuit is merely plaintiff's latest attempt to generate publicity by associating herself with Miss Swift. Unsurprisingly, the claims asserted by plaintiff are unsupported, fail as a matter of law, and should be barred. As a threshold matter, the complaint is a shotgun pleading that impermissibly relies on conclusory, vague, and undifferentiated allegations against all defendants. Plaintiff repeatedly refers to the defendants, Ms. Swift, TAS, RM, UMG, and Bravado, collectively in her allegations without specifying which defendants are responsible for any particular act, despite their highly distinct roles in the music industry and in the creation and distribution of Miss Swift's art. Thus, the complaint fails to give notice of any specific misconduct allegedly attributable to each defendant, fails to satisfy Federal Rule of Civil Procedure 8, and must be dismissed. In addition to this pleading flaw, plaintiff fails to allege facts supporting any likelihood of confusion between plaintiff's mark and defendant's album or related promotional goods, warranting dismissal of her Lanham Act and California unfair competition law claims. Plaintiff's UCL claim also fails as a matter of law because plaintiff 1 seeks to impermissibly apply it extraterritorially against defendants when defendant is not a resident of California and she does not allege facts supporting that any complaint of conduct emanated from California or harmed her there. And 2, fails to plead anti-competitive facts as required for a UCL claim under the unfair prong. Finally, even if plaintiff could plausibly state a claim, this court does not have personal jurisdiction over Ms. Swift or TASRM. Plaintiff's conclusory allegations of nationwide commercial activity rather than any forum-specific conduct purposefully directed at California are insufficient. Plaintiff does not allege acts showing that Ms. Swift or TASRM expressly aimed conduct at the forum, giving rise to plaintiff's claims, nor does she establish the required nexus between any alleged forum contacts and the asserted causes of action. Thus, exercising personal jurisdiction over Ms. Swift or TASRM in this action would violate due process. Plaintiff's pleading failures are inescapable and doom her purported claims. The complaint should be dismissed. Plaintiff's alleged trademark and services. Plaintiff Maren Wade, professionally known as Maren Wade, is a performer and a resident of Nevada. She does not claim to be a resident of California, to have ever performed in California, or to be related to California in any way. She currently owns U.S. trademark for Confessions of a Showgirl with respect to blogs, theatrical productions, and television programs in Class 41. She has allegedly used the mark since approximately 2014 in a written column, a live theatrical production, a book, a podcast, televised video content, YouTube, and social media. Although plaintiff broadly claims she performs across the United States for thousands, the complaint does not identify the frequency, scale, or current status of those performances beyond a single alleged performance in January 2026. Plaintiff does not allege facts supporting when, where, and when, or even if her book, podcast, or digital content were or are distributed. The complaint is devoid of any images or exhibits depicting how plaintiff's mark appears to consumers in connection with her alleged goods, services, and plaintiff does not allege she has ever distributed apparel or indeed any physical goods beside a book in connection with her mark. Despite this pervasive lack of facts, plaintiff generally claims that defendant's use of The Life of a Showgirl in connection with the album and promotional merchandise is likely to cause reverse confusion, and asserts without any cognizable basis that consumers may believe plaintiff's services are affiliated with or derived from defendants. Plaintiff's only allegations on this front is that defendant's commercial scale and reach have overwhelmed her mark and impaired her ability to control her brand, with zero facts supporting actual confusion. Plaintiff is one of many using Confessions of a Showgirl and or Showgirl. Plaintiff's allegations completely ignore marketplace and legal realities, including the extensive use of Confessions of a as well as of a Showgirl by brands and artists across the country. I find it fascinating that they're sitting here whinging about the legal practicalities, how many people want to use these specific words when this is, Taylor Swift is the same person who trademarked 1989. How many people were born in that year, and may want to use it? Plaintiff's mark uses common dictionary terms and a commonly registered phrase with the US Patent and Trademark Office. For example, the following US restrictions, among others containing Confessions of a, presently coexist with plaintiff's mark in Class 41. Confessions of an SEO, Confessions of a CEO with Kelsey Borges, Confessions of a Founder, and Confessions of a Hairstylist. Likewise, there are many US registrations coexisting with the mark containing Showgirl for entertainment services. And the examples I give is Showgirl of the Year, You Showgirl, and Showgirl Neek. Notably, these US registrations are just the tip of the iceberg and are in addition to numerous other third-party uses of Confession of a Showgirl and of a Showgirl in the entertainment industry. Coexisting with plaintiff's mark, third parties have used many variations of these phrases for entertainment-related endeavors for years. And then he talks, the examples they give are Death of a Showgirl, Portrait of a Showgirl, The Last Showgirl, Confessions of a Vegas Showgirl, Confessions of a Shopaholic, and Confessions of a Dangerous Mind, among others. Plaintiff does not allege that the phrases in her mark are unique to her and fails to account for a field full of coexisting marks. Lack of facts regarding the actions of each defendant. Plaintiff's complaint is largely devoid of specific factual allegations as to each defendant. Those facts that were alleged are summarized below. Conclusory allegations to Miss Swift. Plaintiff alleges that Miss Swift is an individual residing in California. As explained below, that is demonstrably wrong. Miss Swift is a resident of and domiciled in Tennessee. Plaintiff also alleges incorrectly that Miss Swift directs substantial commercial activity from this district, including recording, production, and management of her entertainment projects through facilities and business relationships located in Los Angeles County, and that Miss Swift owns one property in California. Even if these allegations were true, nearly all are not. None describes actions taken in relation to the album, its associated promotional goods, or the claims plaintiff asserts. Conclusory allegations as to TASRM. TASRM is a Tennessee limited liability company with its principal place of business in Tennessee. Plaintiff's allegations related to TASRM focus on the company conducting business in California generally, with vague reference to licensing Miss Swift's entertainment projects. Plaintiff alleges that TASRM licenses intellectual property associated with Miss Swift's projects, but does not actually allege TASRM has a licensing relationship with any of the other defendants, or any third party for that matter, with respect to the album or any use of the Life of a Showgirl. Plaintiff makes a conclusory allegation that TAS authorized, directed, and controlled the use of the designation as a trademark across goods and services, without any supporting facts. Plaintiff does not allege TASRM sold any albums or promotional goods in California. Bare bones allegations as to UMG. UMG is a Delaware corporation with its principal place of business in Santa Monica, California. Plaintiff alleges that UMG directs and participates in the commercial exploitation of goods associated with the life of a showgirl, but does not specify or describe what goods UMG is alleged to have been involved with or how it commercially exploited them. Bare bones allegations as to Bravado. Bravado is a California corporation with its principal place of business in Santa Monica, California. Plaintiff alleges that Bravado is responsible for the design, manufacture, and sale of goods bearing the life of a showgirl, but again does not specify or describe what goods Bravado is alleged to have been involved with, or where or how this alleged conduct occurred. Conclusory allegations as to defendants generally. The complaint lumps all defendants together without specifying which entity engaged in which conduct. For example, plaintiff alleges that defendants used the life of a showgirl in connection with, among other things, consumer goods, including drinkware, candles, and apparel, and offered such goods for sale through retail and online channels, but provides no facts supporting which defendant is involved in such actions, let alone which retail or online channels each defendant purportedly offered goods through. In total, Plaintiff impermissibly lumps defendants together over 90 times. Inaccurate application allegations. Plaintiff makes several inaccurate statements regarding the USPTO public record for U.S. trademark application serial number 99331566, covering potential uses of the life of a showgirl. While the complaint alleges that defendants filed the application was filed solely by TAS-RM on an intent-to-use basis, meaning TAS-RM did not represent to the USPTO that it was using the life of a showgirl in commerce and did not submit any specimen of use for any of the applied for services or goods. On November 5th, 2025, the USPTO issued a non-final office action identifying certain purported deficiencies in the application to be adjusted or overcome before a trademark registration would issue. A non-final office action is exactly what it sounds like, not final, and allows the applicant to submit materials to cure any perceived defects, often resulting with a registration issuing. The complaint admits that the office action was expressly non-final and instead characterizes it simply as a refusal, without acknowledging that such actions are preliminary, subject to response, and do not constitute any final determination. The complaint further fails to recognize that the non-final action is partial and does not even concern goods or services in the vast majority of the application's classes. While plaintiff is correct that the application is currently voluntarily suspended, she ignores that when the suspension concludes, TAS-RM will have the opportunity to substantively respond to the USPTO's preliminary office action. Okay. So legal standards. To survive defendant's motion to dismiss under Rule 12b-6, plaintiff must plead facts to show entitlement to relief and must plead more than labels and conclusions or a formulaic recitation of the elements of a cause of action. In evaluating Rule 12b-6 motion, the court may consider complaint allegations, documents incorporated therein, or otherwise integral to the claim, and facts subject to judicial notice. Where a complaint, like plaintiff's, alleges infringement but does not provide images of how the complaint of conduct appears to consumers, courts have taken judicial notice of the allegedly infringing materials by way of incorporation by reference. Further, under Rule 8a-2, a complaint must provide a short and plain statement of the claim showing that the pleader is entitled to relief. A complaint like plaintiff's that violates Rule 8a-2 is known as a shotgun pleading, which fails to give the defendants adequate notice of the claims against them and the grounds upon which each claim rests. Dismissal of a shotgun pleading is appropriate under Rule 12. If the court lacks personal jurisdiction over any defendant, dismissal as to said defendant is required. Jurisdiction over each defendant must be analysed separately and must exist for each claim asserted. Okay, so argument. The complaint should be dismissed pursuant to Rule 12b-6. Plaintiff fails to state a claim upon which relief can be granted on several independent bases. The complaint should be dismissed in its entirety. The complaint is a shotgun pleading that fails to identify which defendant allegedly engaged in wrongful conduct. Plaintiff's shotgun pleading improperly asserting claims against all defendants collectively violates Rule 8a-2, warranting dismissal. A telltale sign of an impermissible shotgun pleading, like plaintiffs, is the use of defendants collectively throughout the pleading without identifying what the particular defendants specifically did wrong. Courts routinely dismiss complaints on this basis. Here, Plaintiff repeatedly refers to the defendants, Miss Swift, TAS, RM, UMG, and Bravado collectively in her allegations of infringement, without specifying which defendants are responsible for any particular act, despite their highly distinct roles in the music industry and in the creation and distribution of Miss Swift's work. For example, plaintiff alleges defendants operated an online store, used the life of a showgirl on apparel items, and worked with third-party national brands, but fails to specify which defendant engaged in any of these purported acts. Plaintiff also alleges defendants purposely directed commercial activities towards California, including the sale of goods bearing the life of a showgirl, but again fails to specify which defendant actually engaged in that alleged conduct. By lumping all defendants together and failing to identify who allegedly did what, plaintiff fails to give adequate notice of the specific misconduct allegedly attributable to each defendant. Plaintiff's shotgun complaint should be dismissed accordingly. The complaint fails to plausibly allege likelihood of confusion. Plaintiff utterly fails to plausibly allege likelihood of confusion, an essential element of her Lanham Act claims. To state a claim, plaintiff must allege facts showing that reasonably prudent consumers, are likely to be confused as to the source, sponsorship, or affiliation of the goods and services at issue. When, as here, reverse confusion is alleged, plaintiff must also show that reasonably prudent getting confused between customers and consumers. When, as here, reverse confusion is alleged, plaintiff must also show that reasonably prudent consumers are likely to believe that defendants rather than plaintiff are the source of the plaintiff's services. If the court determines as a matter of law from the pleadings that the goods are unrelated and confusion is unlikely, the complaint should be dismissed. Courts have dismissed claims where 1. The designs or marks are obviously dissimilar. 2. The designs or marks are placed on products consumed by different groups of purchasers or marketed through different marketing channels. Or 3. The goods or services are unrelated. Plaintiff's alleged goods services are dissimilar to the album and its promotional goods. Plaintiff fails to provide facts supporting that reasonably prudent consumers are likely to be confused between her mark and Miss Swift's album title, let alone that they would mistakenly believe defendants are the source of plaintiff's services or vice versa. Put simply, a comparison between plaintiff's goods or services and defendant's album and promotional goods cannot support a likelihood of confusion as a matter of law. Taking plaintiff's allegations as true, in connection with the life of a showgirl, defendants have released a musical album, drinkware, candles, personal care, accessories, and apparel. Plaintiff, on the other hand, alleges that she has offered a theatrical production, book, podcast, and video content. She does not allege that she has ever sold any of the products defendants sell, nor does she allege that she has released musical albums or performed musical concerts. Unsurprisingly, plaintiff further fails to allege facts supporting that any of the goods or services offered by herself or Miss Swift are related in the minds of consumers. The alleged channels of trade are dissimilar. Plaintiff's alleged channels of trade, including performances at New York City's Laurie Beachman Theatre and Myron's at the Smith Center in Las Vegas, publication in a Las Vegas weekly column, and marketing materials offered on her website, social media, and podcast teaser, further undermine any likelihood of confusion. Plaintiff not only fails to identify when these performances and media placements took place, but she fails to plead that defendants have marketed or sold anything related to the album in connection with those venues or publications. Instead, the only allegation as to where defendants have offered the album and promotional goods is across retail channels. Plaintiff then boldly proclaims, without supporting facts, that those retail channels are directed at the same audience. That those retail channels are directed at the same audience plaintiff has cultivated. The complaint only alleges plaintiff maintains an online presence through the website and provides no information as to her alleged audience. Plaintiff alleges defendants offer the album and promotional goods on defendant's online store, but purposely omits the URL for the website, which includes Taylor Swift emblazoned on the front of the web store, making it unmistakably clear who defendant's goods are affiliated with. Plaintiff has alleged no facts supporting that her alleged performances, podcast, or book are sold or marketed in any of the same channels as the album or its promotional goods. Plaintiff's mark and the album are dissimilar to consumers. Plaintiff relies heavily on purported similarity between Confessions of a Showgirl and The Life of a Showgirl, alleging that the similarity is immediate and that they share a dominant phrase and overall commercial impression. These are conclusory assertions unsupported by factual allegations regarding how consumers encounter or perceive the phrases in the marketplace. Tellingly, plaintiff omits any photographs or descriptions of how her mark or the album and corresponding promotional goods actually appear to consumers. Courts have dismissed trademark infringement claims for failure to allege facts, supporting likelihood of confusion even where they contained a good deal more information about the alleged marks than here. When actually viewing plaintiff's mark and the album and its promotional goods, it is clear they are dissimilar. Specifically, they differ as to dominant terms, meaning font, coloration, spacing, and overall commercial impression as depicted below. They're being selective there, I think, with Maren Wade's historical branding, because in the opposition to the preliminary injunction, they were making the opposite claim, i.e. that, well, her branding is, she's now changed it since the album was released to make it similar to Taylor Swift's. And actually it preceded the release of Taylor Swift's album, the examples they used, and they have deliberately, selectively chosen not to put them here. So yeah, there is that. It's a bit disingenuous. Plaintiff's allegations regarding actual confusion are conclusory. Plaintiff asserts that multiple instances of actual consumer confusion have been documented across public platforms, but provides no examples or details of the alleged confusion. Such vague allegations are insufficient to plausibly establish likelihood of confusion. Nor does the complaint adequately plead reverse confusion. Although plaintiff alleges that defendant's scale may overwhelm her brand, she crucially does not allege facts showing that an appreciable number of consumers believe defendants are the source of plaintiff's cabaret performances, or vice versa. Plaintiff's reliance on the USPTO's purported refusal to register defendant's mark does not support her claims of confusion here. The complaint asserts that the USPTO itself confirmed the conflict when it refused defendant's application on the ground of likelihood of confusion, but omits the critical facts that this was 1. Merely a non-final office action, 2. Related to an intent to use trademark where no specimens of use were submitted, and 3. The USPTO explicitly did not find likelihood of confusion between plaintiff's mark and the majority of the goods or services covered in the application. Plaintiff's attempt to dress up a non-final office action into a dispositive proof of a likelihood of confusion not only fails as a matter of law, but also highlights plaintiff's lack of plausible facts to support consumer confusion, and further, her fundamental misunderstanding of trademark law and USPTO procedure. In sum, Plaintiff's allegations simply amount to formulaic recitations of the likelihood of confusion element of a trademark infringement claim without any facts to support them. This is insufficient, and plaintiff's claims should be dismissed. Plaintiff's UCL claim fails as a matter of law. Plaintiff's allegations fail to state a claim under California's unfair competition law. A UCL claim requires plaintiff to allege an unlawful, unfair, or fraudulent business act or practice that causes her to have suffered injury in fact and lost money or property. Here, plaintiff alleges unlawful and unfair conduct, but fails to plausibly allege any anti-competitive activity required for an unfair claim and improperly attempts to impose liability for conduct and injury that allegedly occurred outside of California. Plaintiff's UCL claim must be dismissed. The UCL does not apply extraterritorially. Plaintiff has failed to allege actions taken by defendants in California sufficient to state a claim under the UCL. Courts routinely reject UCL claims where the alleged misconduct and or injury occur outside California, or where the complaint fails to tie the alleged challenge conduct to the state. If only Blake Lively's best friend Taylor Swift could have told her this when she, no, don't try to apply Section 47.1. Nothing happened in California. Okay. Here, plaintiff does not allege facts to plausibly support that any relevant conduct emanated from or caused injury in California. At most, she alleges that defendants conduct business in California, and that products may reach consumers there. That is woefully insufficient. First, plaintiff is a Nevada resident. Thus, any purported injury to her took place outside California. Second, the complaint does not allege facts supporting the notion that the relevant conduct was conceived, reviewed, approved, or controlled in California as to each defendant as required to state a UCL claim. Plaintiff's allegations that defendants engaged in California-based sales or participated in unspecified coordinated activities purportedly directed and controlled in part by entities with a California presence are entirely conclusory and do not identify where the alleged misconduct actually occurred or emanated from. The allegations that UMG and Bravado have a California presence does not change this conclusion. Nowhere does plaintiff allege that decisions related to the commercial exploitation of goods associated with the life of a showgirl occurred in California, nor does plaintiff allege that any decision or act related to the design, manufacture, or sale of goods bearing the life of a showgirl designation occurred in California. Plaintiff simply does not allege that the decisions to engage in the complained of conduct were made in California. Plaintiff's UCL claim is even more deficient. As to Ms. Swift and TAS-RM, there are no factual allegations that any relevant decisions or conduct by Ms. Swift or TAS-RM occurred in California. TAS-RM is a Tennessee company that does business from Tennessee and has no specific connection, alleged or otherwise, to California, let alone to the complained of conduct. Ms. Swift is domiciled in Tennessee, and the complaint does not provide any nexus between Ms. Swift allegedly owning a property in California and plaintiff's UCL claim. Alleged affiliation with entities connected to California also does not establish that Ms. Swift or TAS-RM engaged in conduct emanating from California, particularly where the complaint fails to connect any specific acts by those defendants to the forum. Plaintiff has failed to allege facts supporting that the complaint of conduct was undertaken by any defendant in California or caused harm to her in California. Because the UCL does not apply extraterritorially, it should be dismissed. Plaintiff's unfair allegations fail to state a claim. Plaintiff alleges that defendant's conduct is unfair within the meaning of the UCL, but has pled zero facts supporting that assertion. Under the UCL, unfair means conduct that threatens an incipient violation of an antitrust law or violates the policy or spirit of one of those laws, or otherwise significantly threatens or harms competition. Acts that violate the spirit of the antitrust laws include horizontal price fixing, exclusive dealing, or monopolization. Plaintiff pleads no such conduct, and instead rests her unfair theory on conclusory allegations that defendant's conduct offends established public policy embodied in state and federal trademark law to obtain an unfair competitive advantage over plaintiff. This is precisely the type of ambiguous allegation California courts have found insufficient to state a claim. Moreover, plaintiff's alleged injury is the impairment of her ability to control and expand the confessions of a showgirl brand, loss of exclusive control over the mark source identifying function in the marketplace, and displacement of her brand in the digital channels through which she reaches her audience and generates revenue. Even if valid, every one of those allegations describes harm to plaintiff as an individual. None alleges harm to competition itself as required by the UCL. Plaintiff has failed to adequately allege unfair conduct by any defendant. This portion of plaintiff's UCL claim should be dismissed. The court lacks personal jurisdiction over Ms. Swift and TASRM. Plaintiff has not shown that personal jurisdiction as to Ms. Swift and TASRM is proper. Personal jurisdiction is over a non-resident defendant can only be exercised where the defendant has minimum contacts with the relevant forum, such that maintenance of the suit does not offend traditional notions of fair play and substantial justice. California's long-arm statute allows courts to exercise personal jurisdiction to the extent permitted by the Due Process Clause. Personal jurisdiction exists in two forms, general and specific. General jurisdiction is based on a defendant's continuous presence in California without regard to where the cause of action arose, whereas specific jurisdiction refers to the specific contacts with the state specifically related to the claims at issue. Here, plaintiff fails to satisfy her burden of showing that either form of personal jurisdiction is proper over Ms. Swift or TASRM. They should be dismissed from this action. There is no general jurisdiction over Ms. Swift or TASRM. Ms. Swift and TASRM are not subject to general jurisdiction in California. For an entity like TASRM, general jurisdiction exists where a defendant has continuous and systematic contacts with the forum. In almost all instances, that will be the company's place of incorporation and principal place of business. Only in an exceptional case will a defendant's operations in another forum be so substantial as to render it subject to general jurisdiction there. For an individual like Ms. Swift, the paradigm forum for general jurisdiction is the individual's domicile. A domicile is not merely where an individual may own a residence, it is the location of an individual's permanent home. And the mere presence of property in a state is insufficient to exercise general jurisdiction. Accordingly, requests to exercise general jurisdiction are routinely denied over individuals and entities who own property in California but are not domiciled there. Plaintiff does not and cannot establish that either Ms. Swift or TASRM are subject to general jurisdiction in California. As to Ms. Swift, plaintiff alleges that she is a resident of California, but that is incorrect. Ms. Swift is domiciled with her permanent home in Tennessee. Plaintiff's other allegations that Ms. Swift owns one property in California and directs substantial commercial activity from this district are also insufficient. As explained, mere ownership of property does not equate to domicile, and because Miss Swift is an individual, any purported direction of commercial activity from California, if it occurred at all, is irrelevant to the general jurisdiction inquiry. As to TASRM, it is undisputed that it is a Tennessee company with its principal place of business there. Even if TASRM conducts business in California, that is woefully insufficient for general jurisdiction, as even substantial business activity in a state does not do so absent exceptional circumstances not alleged here. There is no general jurisdiction in California over Miss Swift or TASRM. Specific jurisdiction over Miss Swift and TASM is also lacking. Because general jurisdiction is absent, plaintiff must establish specific jurisdiction over Miss Swift and TASRM. Plaintiff has failed to make that showing. To exercise specific jurisdiction over Miss Swift and TASRM, plaintiff must allege facts supporting 1. Miss Swift and TASRM purposely directed activities at California. 2. Plaintiff's claims arise out of or relate to Miss Swift and TASRM's foreign-related activities. And 3. The exercise of jurisdiction is reasonable and fair. Plaintiff bears the burden on the first 2 prongs. If either fails, specific jurisdiction is absent. Here, plaintiff fails to allege facts supporting any of the 3 requirements. No purposeful direction towards California exists. For tort-based claims such as Lanham Act and UCL claims, courts analyze the purposeful direction prong by applying the Calder effects test. Under Calder, plaintiff must show that Miss Swift and TASRM 1. Committed an intentional act, 2. Expressly aimed at California, and 3. Causing harm that they knew is likely to be suffered in California. Express aiming requires something more than a foreign act with foreseeable effects in California. Even if allegedly infringing products are sold in California, courts have declined to find express aiming where the specific defendants did not personally sell them or they were generally available to the public. Plaintiff has not satisfied Calder. She does not allege that Miss Swift took any action in California or expressly aimed conduct there with regard to the album or any promotional merchandise. Even if it is true, it is not. This would be an insufficient showing because plaintiff does not tie any of this purported commercial activity to the album-related promotional merchandise or anything related to the life of a showgirl. Additionally, plaintiff merely alleges that TASRM conducts business in California and participates in the ownership, control, licensing, and commercialization of intellectual property associated with Miss Swift's entertainment projects, including the life of a showgirl. But this does not support the notion that TASRM expressly aimed conduct at California as opposed to other states. Even if this generalized allegation was enough, and it's not, the enclosed declaration refutes it. Specifically, TASRM's operations are in Tennessee. Plaintiff's allegations related to offering and selling goods bearing the life of a showgirl. Bearing the life of a showgirl designation on websites accessible to consumers in California are similarly insufficient. Even assuming the truth of the allegation, plaintiff does not allege that Miss Swift or TASRM did anything more than make goods available through online channels that are offered through websites used by consumers in this district. Simply making goods broadly available without any specific advertising to or direction toward California consumers does not support jurisdiction. Finally, nothing in plaintiff's complaint supports that Miss Swift or TASRM were even remotely aware of any harm that could conceivably result in California. Plaintiff admits that she is a Nevada resident and does not allege any harm to her occurring in California. Plaintiff has failed to satisfy the purposeful direction prong, which alone dooms her claims against Ms. Swift and TAS-RM. The claims do not arise from any California activities by Ms. Swift or TAS-RM. On the second prong of the specific jurisdiction analysis, plaintiff must show that each claim arises out of or relates to the defendant's forum-related conduct. A direct nexus between defendant's contacts with the forum and the plaintiff's alleged injury is required. If they are unrelated to the plaintiff's claims, specific jurisdiction fails. The Ninth Circuit applies a but-for test, asking whether plaintiff would have suffered the alleged injury but for defendant's forum-related conduct. Jurisdiction is improper where a defendant's activities in a forum lack any connection to the plaintiff's claims, as is the case here. Yamashita and Cole Palmer are instructive. There, despite the defendant's product sales in the forum, jurisdiction was rejected because the plaintiffs could not tie their injury to those forum contracts. The same defect is present here. Plaintiff is a Nevada resident and does not allege any meaningful connection to California, let alone that her alleged injury arises from conduct occurring in or directed to California. She does not allege that she has ever performed in California or targeted California with any goods or services related to her trademark, nor does she allege that the purported infringement or resulting harm is tied to California-specific activity. Likewise, as in Cole Palmer, plaintiff fails to provide any factual support for the notion that Ms. Swift or TAS-RM personally sold the album or promotional merchandise in California. Merely engaging in purported licensing activity with an entity in California is not enough. As in Yamashita and Cole Palmer, plaintiff identifies generalized assumed forum contacts but fails to connect those alleged contacts to any conduct giving rise to her claims. This is insufficient as a matter of law, as plaintiff has not established that her claims arise out of or relate to TAS-RM or Ms. Swift's purported California contacts. The second prong is also not satisfied and specific jurisdiction cannot be established. Exercising jurisdiction is unreasonable. Even if plaintiff could satisfy the first two prongs, she cannot. Exercising jurisdiction over Ms. Swift or TAS-RM in this trademark infringement matter would be unreasonable. The relevant factors guiding the reasonableness inquiry are 1. The extent of defendant's purposeful interjection into the forum state's affairs. 2. The burden on defendant of defending in the forum. 3. The extent of conflict with the sovereignty of defendant's state. 4. The forum state's interest in adjudicating the dispute. 5. The most efficient judicial resolution of the controversy. 6. The importance of the forum to plaintiff's interest in convenient and effective relief. And 7. The existence of an alternative forum. These factors weigh heavily against imposing personal jurisdiction over Ms. Swift or TAS-RM. As explained above, Ms. Swift and TAS-RM's purported activities arise solely from nationwide conduct, lacking any specific nexus to California. Additionally, requiring Ms. Swift and TAS-RM, both domiciled in Tennessee, to defend themselves in California would be burdensome and would impose on Tennessee's interest in adjudicating rights related to its citizens. This is especially the case where California's interest in this matter is limited to non-existent given that the plaintiff is not a California resident and the operative facts have no tie to California. There is nothing about this forum that increases an efficient resolution. Indeed, this district had the second highest caseload of any court in the country in 2025. An adequate alternative forums exist, including Tennessee, where Miss Swift and TASRM are domiciled. Plaintiff does not plausibly allege that Miss Swift or TASRM have purposely directed any activity towards California, let alone related to her claims, and it would otherwise be unreasonable to require Miss Swift or TASRM to defend themselves in the district. Personal jurisdiction is lacking, and they should be dismissed accordingly. For the foregoing reasons, this court should grant defendant's motion and dismiss the complaint. I'm not going to comment too much on this at the moment, for good reason, actually, because I want to do my next video, which is the response, because this was a bit of a... oh, what's the word I'm looking for? A bit of a sneaky move by Taylor Swift's attorneys here. They filed this motion to dismiss and timed it specifically with an upcoming hearing. And I wanted to go through the response first, and it's not, I don't think it's a full opposition. I think it's just a response on record, but I wanted to put it all together and then maybe have a think about some facts. But I always like to look at, like, this on itself, when I'm reading it, actually sounds very strong. And if a lot of the stuff in here is true, especially about the jurisdictional issues, then I could see Taylor Swift and TASRM being dismissed. I would hope, though, if that's the case, it would be on a without prejudice basis, and Maren Wade then could bring the claims in another forum, potentially Tennessee. But I don't know. I want to see the opposition. I always like to see the opposition and balance the arguments. Okay. Let me know what you think. And I will be doing the follow-up with the kind of the response on record from Maren Wade.